sticking with the first, to Graca v. Garland, again, I wanted to stick with the good, right?
Yeah.
And this is back to crimmigration, and this is about Rhode Island, what is it? Rhode Island burglary, I believe. Yeah, Rhode Island, or maybe car theft. I can't even remember at this point. But in this case, it's the First Circuit really applying. It just shows how different courts are doing this categorical approach to immigration so differently. This decision seems unlikely to be published under the current Board of Immigration Appeals, but of course the First Circuit is a very different entity, nor does the First Circuit owe any deference to how the Board of Immigration Appeals applies the categorical approach. And in this case, it did something really interesting. Again, it's about divisibility, and it's about whether or not the different ways of committing an offense are elements rather than means. In this case, we've got a conviction that would match the definition of an aggravated felony theft offense. But under matter of ZVS, if a conviction encompasses like stuff like joyriding, temporary taking without the intent to keep it permanently, and I'm paraphrasing, and listen to the podcast for the true non-paraphrasing. If it's going to criminalize joyriding, then it doesn't match the definition of an aggravated felony theft offense. In this de Graca decision, the First Circuit said, okay, we're not sure if this statute criminalizes joyriding, but it could, probably, just looking at it. And we can't find any other statute in Rhode Island where this was that does criminalize joyriding. So that means to us that this statute likely criminalizes joyriding. That's very interesting to me. That's not necessarily finding a case. That's not necessarily even the statutory text. It doesn't say, you know, joyriding. It's the First Circuit using the absence of another conviction, another statute of conviction, to say that the statute in front of it is overbroad, that it must encompass joyriding, because we can't find anything else that does. Mm-hmm. That's a pretty powerful crimmigration analysis, depending on your case, as I said on the podcast. And I don't know how applicable it is, and there's a lot more going on in de Graca, don't get me wrong, but if you the logic would then go, you've got a case, figure out how it would be overbroad vis-a-vis a removable offense, then look at the whole statutory scheme and find that in the state there is nothing that criminalizes that overbroad offense. Mm-hmm. And voila, you've got a de Graca type analysis. It's interesting stuff. I love these tools. I love the categorical approach. It's like a big puzzle to me, and I enjoy it a lot.